Imagine being born in the US, yet not becoming a citizen. Sounds unreal, right? But that's exactly what a new policy is trying to do. What does it mean to be a citizen? It's a question with profound implications, defining who belongs, who has rights, and who can participate fully in a nation's life. In the United States, one of the most fundamental answers to this question is found not in bloodlines or ancestry, but in the very ground beneath our feet. This is the principle of birthright citizenship, a concept that has shaped the nation's identity for over 150 years. Its origins are rooted in the ashes of the Civil War. In 1868, the nation ratified the 14th Amendment, a revolutionary act of constitutional engineering. Its primary goal was to dismantle the legacy of slavery and overturn the Supreme Court's infamous 1857 Dred Scott decision, which had cruelly declared that African Americans, whether enslaved or free, could never be citizens. The amendment's citizenship clause was a direct and powerful repudiation of that ruling. It states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens." This was designed to grant indisputable citizenship to formerly enslaved people and ensure that a permanent, stateless underclass could never again exist on American soil. This established a legal doctrine known as jus soli, a Latin term for right of the soil. The principle is simple. Your citizenship is determined by your place of birth. This stands in stark contrast to the world's more common model, jus sanguinis, or right of blood, where citizenship is inherited from one's parents. The American embrace of jus soli was a deliberate choice, reflecting an ideal that national identity should be based on shared geography and civic participation, not ethnic or ancestral ties. The strength of this new constitutional guarantee was put to the test just 3 decades later in the landmark 1898 Supreme Court case. Wang was born in San Francisco to Chinese parents who were legal residents but were themselves ineligible for citizenship due to the discriminatory Chinese Exclusion Act. When he was denied re-entry to the U.S. after a trip to China, the government argued he was not a citizen. The Supreme Court disagreed. In a landmark decision, it affirmed that Wang, having been born in the U.S., was subject to the jurisdiction thereof, and therefore a citizen under the 14th Amendment. This case cemented birthright citizenship as the law of the land, confirming it applies even to the children of foreign nationals born on U.S. soil. For generations, this principle has been a core constitutional protection, a bedrock of American law that ensures every person born here begins life with the same fundamental status. It means that regardless of who your parents are or where they came from, birth in the United States makes you a U.S. citizen. On January 20th, 2025, in a move that reverberated across the nation, President Trump signed a highly anticipated executive order. Its official title, Protecting the Meaning and Value of American Citizenship. The name itself frames the administration's narrative, that the long-standing practice of birthright citizenship has somehow diluted the very concept of what it means to be an American. This action wasn't a surprise. It was the fulfillment of a promise made repeatedly on the campaign trail and during his first term, a direct challenge to a cornerstone of American law that has stood for over 150 years. The order's text is precise and its scope is vast. It argues that children born in the United States should not automatically become citizens if their mother is unlawfully present. This targets families who may have crossed the border without authorization or overstayed a visa. But the policy goes significantly further, also including mothers who are lawfully present, but only on a temporary basis. This is a critical distinction that dramatically expands the order's reach. It encompasses a huge and diverse group of people who are in the country legally: international students pursuing degrees at American universities, skilled professionals on temporary work visas like the H-1B, journalists on assignment, and even tourists. The final condition is that the child's father must also not be a U.S. citizen or a lawful permanent resident. In essence, the order targets families where neither parent has a permanent settled immigration status, regardless of their legal standing at the time of their child's birth. To understand the gravity of this executive order, we have to look back to the period just after the Civil War. In 1868, the United States ratified the 14th Amendment. Its citizenship clause was revolutionary, stating, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." This language was specifically designed to overturn the infamous 1857 Dred Scott decision, which had denied citizenship to African Americans, and to ensure that formerly enslaved people and their descendants were recognized as full citizens. For over a century, this clause has been understood to grant citizenship to virtually everyone born on U.S. soil. This interpretation was cemented by the Supreme Court in the landmark 1898 case, United States versus Wong Kim Ark. Wong Kim Ark was born in San Francisco to Chinese parents who were legal residents, but were barred from becoming citizens themselves by discriminatory laws at the time. After a trip abroad, the government denied him re-entry, claiming he wasn't a citizen. The Supreme Court disagreed. In a decisive ruling, it affirmed that Wong Kim Ark was indeed a citizen by virtue of his birth in the United States, establishing a powerful precedent that has guided American law ever since. This long-standing precedent is now at the heart of an immense legal battle. The administration's lawyers are focusing their argument on 5 key words in the 14th Amendment, subject to the jurisdiction thereof. They contend that the parents of these children, whether here unlawfully or on temporary visas, owe allegiance to a foreign government, and are therefore not fully subject to the jurisdiction of the United States in the way the amendment's framers intended. However, the vast majority of constitutional scholars argue this is a misreading of history and law. They maintain that jurisdiction simply means being subject to U.S. laws, which everyone physically present in the country is. They argue that an executive order cannot unilaterally reinterpret the Constitution, a power reserved for the courts or the arduous process of a constitutional amendment. If the order were to survive the inevitable legal challenges, it would create a profound and immediate societal shift. A new, multi-generational class of American-born non-citizens would emerge. These children, raised and educated in the United States, would exist in a state of legal limbo, potentially lacking access to basic services, and facing an uncertain future upon reaching adulthood, unable to legally work, vote, or fully participate in the only society they have ever known. The human cost would be immense, affecting families from all walks of life, from the agricultural worker in California to the tech entrepreneur in Silicon Valley. The executive order states it will take effect for all births occurring 30 days after its signing. This sets a hard deadline, February 19, 2025. But this 30-day period is not a quiet countdown. It's the starting gun for a legal war. Civil liberties organizations have already vowed to sue, and legal experts anticipate that federal courts will issue temporary injunctions to block the policy's enforcement almost immediately. The signing of this order is not an end, but the explosive beginning of a constitutional crisis that will almost certainly be decided by the Supreme Court, forcing a modern-day reckoning with the 150-year-old question, who is an American? This change could affect over 150,000 babies born each year in the U.S., denying them citizenship, and potentially leaving them stateless. Experts warn it could create a newly disadvantaged class, children without full rights or protections. That's why the legal fight matters so much. The ink on the executive order was barely dry before a legal firestorm erupted. Almost immediately, a coalition of civil rights organizations, immigration advocacy groups, and several state attorneys general filed a barrage of lawsuits across the country. Their legal challenge was built on a foundation over 150 years old, the Citizenship Clause of the 14th Amendment. They argued that the president had unilaterally attempted to rewrite the Constitution, bypassing Congress and ignoring more than a century of established legal precedent. The core of their argument was simple yet profound. The executive branch does not have the authority to strip citizenship from individuals born on U.S. soil. The nation braced for a constitutional showdown of historic proportions, one that would test the limits of presidential power and the enduring meaning of American identity. In courtrooms from California to New York, the challengers sought immediate relief. They requested preliminary injunctions, a powerful judicial tool to temporarily halt a policy's enforcement while its legality is debated. Federal judges, one after another, sided with the challengers. They issued scathing rulings, calling the executive order a likely overreach of executive authority and fundamentally unconstitutional. Many of their decisions explicitly cited the landmark 1898 Supreme Court case, which affirmed that a child born in the U.S. to non-citizen parents was, in fact, a citizen. These injunctions effectively froze the executive order in its tracks, creating a nationwide legal blockade and handing the administration a series of stinging initial defeats. Facing a united front from the lower courts, the administration appealed, escalating the battle directly to the nation's highest court. The case, now consolidated and known as, became the focal point of the entire debate. CASA, a prominent immigrant rights organization, stood as the lead plaintiff representing countless families who were suddenly plunged into a state of uncertainty. The stakes were immense. The administration's lawyers prepared to argue that the phrase, "subject to the jurisdiction thereof" in the 14th Amendment had been misinterpreted for decades and was never intended to apply to the children of undocumented immigrants. On June 27, 2025, the Supreme Court issued its highly anticipated ruling. But it was not the decisive verdict on birthright citizenship that many had expected. Instead, the court delivered a narrow procedural decision that sidestepped the central constitutional question. In a 5-4 opinion, the majority ruled on the "not the." They declared that federal district courts do not have the authority to issue nationwide or universal injunctions. The ruling stated that a judge could block the policy, but only for the specific plaintiffs involved in that particular lawsuit, not for the entire country. The majority argued that allowing a single judge to set policy for all 50 states represented a judicial overreach. This limited ruling fundamentally changed the nature of the fight. While the plaintiffs were protected, the executive order could theoretically be enforced everywhere else. The decision dismantled the nationwide legal shield and created a confusing state-by-state patchwork of rights. It meant that a child born in one state might have their citizenship recognized while a child in another could be denied it, pending further lawsuits. For advocacy groups, the ruling transformed one monumental legal battle into hundreds of smaller, more complex, and far more expensive ones. The Supreme Court had punted on the ultimate question, leaving the fate of birthright citizenship unresolved and ensuring the legal war would continue, now fought on multiple fronts across a divided American landscape. Despite the Supreme Court's ruling, the order hasn't taken effect. On July 10, 2025, a judge granted a class-wide injunction to protect all current and future children who could lose citizenship under this order. So for now, birthright citizenship still stands, but the fight isn't over. If the policy were enforced, families could face legal uncertainty, difficulty obtaining passports or social security numbers, and sometimes even denied access to health care or school. Immigration advocates say that for now, hope lies in the courts and the 14th Amendment. That constitutional promise remains central. So that's the story, a bold policy aiming to end birthright citizenship, powerful lawsuits still defending it, and a legal system still keeping the promise alive, for now. Thanks for watching and stay informed.